in particular in the European Union agreements. And I start with a few questions on how can the European Union affect protection of human rights in the wider world. So does the European Union have the tools, the capacity of protecting human rights outside its border? And what kind of tools can the European Union use to achieve this objective? The other question, the first part, is what are the place of human rights in the context of promoting values? I think you already discussed a little bit about the values and the European Union structure. But I will go in very briefly into that again and make things clear to give you the context of the further question. So the second part is human rights as a limitation for European Union action. Why spend some words about this issue? Because if the European Union wants to promote human rights, I think it has to show consistency that the European Union itself respects human rights when it acts with the other countries outside the European Union. And finally, and also this second part has its own question, which is quite obvious. What are the limits that the European Union encounters when it concludes agreement with third countries, as far, of course, as human rights are concerned? Finally, the main part, the third part, on human rights protection and promotion outside European Union borders. So the question here is, what are the mechanisms that European Union use in order to enhance human rights protection in third countries? And we will see, we'll mainly discuss the human rights clause, the so-called human rights clause, or clauses, as I will explain. That is a provision made of two parts, actually, that the European Union includes in all its agreements, and is a mechanism of conditionality. So I will explain what conditionality is, when it is applied, and then we'll discuss the human rights clause. So this is the outline of this lecture. So first part, I will take the slide about question. So the European Union is, this is the question, is the European Union an international actor? How this entity can in fact affect human rights outside its borders? So the European Union as a world actor requires us to think about the nature of the European Union. I think you discussed it with Professor Pasquali, the first lecture you had in the winter school. So you know that the European Union can be described in several different ways. But one is the European Union, from the international point of view, is an international organization. What does it mean? What are the characteristics of international organizations such as European Union? Usually, the European Union is described as a sui generis international organization because it has some characteristics which are not shared by any other international organization in the world. But of course, it's not a state. So a state, why do I underline the fact that the European Union is an international organization? Keep in mind the question that I ask you to think about: how the European Union can promote, can protect human rights. It needs to have tools to do that. So the European Union is an international organization, and this is a limit, in a certain sense, for the European Union to act. Why? Because sorry, I didn't see your hand.
Well, because it's composed by other subjects of law, specifically nation states.
Yes, right. It's I'd say these parts are member states, but member states created the European Union. So the European Union is a creation of states. Another thing that is very often you can hear very often is that the member states are the masters of the treaties. So the European Union does not have the characteristic of a sovereign state. A state as a number of competencies that European Union does not have. So this is very important. The other element which we have to bear in mind is that the European Union is I wrote on the slide market, is an important market. Why is an important market? Not only for the number of persons living in the European Union, not for the number of citizens, which are more than 100 million. Why is important?
Because of fiscal GDP and how much money is available.
Okay, right, because these consumers are rich consumers, they spend money. So for any company, any business outside the European Union, it's very important to be able to sell goods to services to enter into the market.
Yeah, because the European Monetary Union is the second mostly valued currency in Europe.
Yes, this is very important as well. Yes, of course. But the euro is a strong currency. So the European Union has the capacity of affecting, let's say, the international economy. Mind this, it's a huge market, it's an important market, it's a rich market, in the sense that I explained, but it's also a market which is heavily regulated. The United States are an important market, a rich market, they have product, but I'm exaggerating a little bit, but they do not regulate. There is a approach of the regulation of the market. The European Union action is to regulate the market, the internal market, but as we will see, the fact that the European Union is an important market, has a capacity and the will of regulating the market, this affects the international economy. If a company, a business wants to, as I said, enter the market, sell its goods, sell its services, it has to respect this regulation. So this is important because the European Union has a strong influence on the global market. As I said a few minutes ago, it is an international organization. I want to come back to this point. So it has a limited number of competencies. As we said, that the European Union as an international organization is created by states. States confer competencies and powers to the European Union. So we can say, on the other way around, the European Union has only the competencies that are conferred to it by the states. And where do we find this competence? How do I know whether the European Union has a competence to regulate transport in the Union, or it has a competence to conclude a trade agreement? Where do I find this?
As long as it does not violate territorial integrity and national sovereignty.
Yes, maybe my question wasn't clear. My question is, where do we find the answer to the question, does the European Union has a competence to regulate transport? In the treaties, on the basis of what you have in the slides, the Article 5 of the Treaty on the European Union, the principle of conferral. Under the principle of conferral, the Union shall act only within the limits of the competencies conferred upon it by the member states in the treaties to attain the objectives set out in treaties and check that. Why is this important? Because any action of the European Union needs to find its basis in the treaty. So this is important because if we are discussing we are answering the question, how can the European Union affect protection of human rights? We have to be aware that the European Union has limited competence, although they have been expanded by the modification by amendment of treaties and also by the case law of the European Court of Justice, but I don't have time to go into this issue now. But what is important is that you are aware that the European Union can act but within the limits of its competences, although these competences have been enlarged and expanded. What are the fields of external competencies? These are important to affect human rights. There are some fields that are only the external feature, that is the commercial policy. Common commercial policy is trade outside the European Union. Otherwise, trade within the European Union is free circulation of goods, services, person, capitals. And humanitarian aid, development, cooperation, these are fields of external competence of the Union. Then we have fields of competence, like for instance the environmental one, which is the field of competence within the Union. The Union can enact regulation in the field of environmental protection, but it can also conclude an agreement containing provisions on environmental protection. And then we have, I mentioned it before, we have the internal market regulation that affect more or less indirectly the regulation also outside the European Union. What I hope I have time to speak about that. What is called the Brussels effect, which is an expression coined by Anne Bradford, who is a professor of European law at Columbia University. So this is the general context, and then we have to consider tools, because when the European Union doesn't act with an army, it acts with laws. It can enact unilateral legislation, directives, regulations, decisions, but it can also conclude agreements with third countries in the areas where it has competence, of course. So these are the tools, the instruments used by the European Union to interact with third countries. Of course, it's obvious that it interacts with third countries through the conclusion of an agreement, but it can affect a certain situation, a human rights situation in third countries, also by enacting unilateral legislation, like regulation. We will have an example in a moment about this influence of unilateral acts, and I will speak about the general system of preferences of the European Union as a tool to influence, to affect human rights protections in third countries. We will, of course, focus mainly on trade and cooperation agreements concluded by the European Union with third countries. So we, I think it's important to be aware of the objectives of the trade, the common commercial policy of the European Union. These are listed very general terms in Article 206 of the Treaty on the Functioning of the European Union. The Union shall contribute in the common interest to the harmonious development of world trade, the progressive abolition of restrictions on international trade and on foreign direct investment, and the lowering of customs and other barriers. What can you say after reading Article 206 about the objectives of common commercial policy? Yeah.
The target is the complete liberalization of trade.
Yeah, the approach is of liberalization, which is opposed to what we are seeing. Yes, protection. We are seeing many important countries that are moving towards protecting measures of their markets. So, yeah.
I have a question that's actually, what about strategic autonomy? And how that applies with protectionism to defend certain strategic sectors, such as energy, and these objectives written in the treaty?
I'm not sure I understand your question. You are asking me if the European Union should be more protectionist to...
No, the EU has its goal of becoming more autonomous in a strategic way. Within the treaty is written that it shall liberalize trade. How do you balance this?
Well, trade is usually applied to goods, to free circulation of services. Of course, energy is good, but there may be compensating some aims, some objectives with other important objective and interest of the Union. There is a balance that is made. Of course, it's not easy And there are a lot of rules in international law about commerce, about trade. For instance, I'm thinking about the World Trade Organization, and there are clauses like the Article 19 of the General Agreement on Tariff and Trade, which is reproduced also more or less with the same words in the other agreements, specialized agreements of the WTO, that provide a possibility for the states for some non-trade objectives to protect their markets. So there is a balance that needs to be, of course, made, and which is a difficult one in many instances.
Can I add? Because I feel like also the view of the European Union has changed from this like free trade liberalism to after we see, well, of course, the war in Ukraine and also the rise of China. We became so dependent on the Russian gas in China for technology. So for the energy transition alone, I think the strategic autonomy now gets more priority over the free trade. Is that also the element that you see, or?
Well, this situation is very different when you talk about Ukraine, of course, because there is a war. And so there are some intervention by the European Union to help Ukraine, for instance, the exports of agricultural products. And this is creating a problem within the Union, as you might be well aware. It's very recent, these days, there is a strong discussion about the competition of agricultural products from Ukraine, but not only that, because as you can see in the streets and roads today, there is a discussion, the agricultural the farmers, they are strongly opposing some policy of the European Union towards described in some of the European agreements that you are discussing today, even if our discussion is more on the human rights, but there is opening of the market and competition of the market, but at the same time, the European Union is trying to protect its values like the health and safety of products, so it can enact its regulation, and products from Argentina, Brazil, or South Korea have to comply with these rules. So there is opening, but there is also very careful. The European Union is very sensitive to all this question that might be presented a form of protection, if you want, of the market. But with China, the issue is much more complicated by the geopolitical situation nowadays. So if we go on with this observation that I'm developing, common commercial policy as, let's say, economic objectives. The European Union Treaty in Article 207, after describing the content of commercial policy, because the question is what we put in the box with the label of trade policy, common commercial policy. This is a very much discussed issue. But what I want to underline here is the last part of paragraph 1 of Article 207, when it is said that the common commercial policy shall be conducted in the context of the principles and objectives of the Union external action. So it's connecting, the treaty is connecting Article 207 and general terms of common commercial policy with the values and the principles that underlines external action of the European Union. Before say something about this, even if I think it's a repetition of what you might have seen in this day, yesterday or this morning. So before going back to Article 21 of the treaty, European Union, this slide that I took from the website of the European Commission, just to give you a very general overview of the network of trade agreements that the European Union has concluded or is in the phase of negotiating, or that have to be ratified. So you have the dark red, the agreement in place, agreement that are working, and then those in dark blue, agreements that are in the phase of a negotiation. Then there are some in yellow that they are negotiating now. So it is there's still time to arrive to a signature, and some other are on hold because there are some difficult situations in those countries. So finally, the first question, if you remember, that I asked you in this first part of the lecture is the European Union a world actor? Can it have an impact on protection of human rights abroad? In theory, yes, because I would say that the European Union, with all the limits that we saw, in particular the fact that it doesn't have the competencies of a state, but only the competencies that are conferred to it by states, as a power, of course, is not a military power. The European Union is a different kind of power, but I would say that it has a power to impact on the distribution of resources around the world, for the fact that it is a very important, huge market. It has a very important currency, what we mentioned before. It can have an impact on defining values, very general terms, also on the side of economics. We just said that the European Union approach to trade is one of liberalization. Although, as one of you rightly noticed, there is a tension between this liberalization ethos of the European Union and the situation that are taking place in the world today, and it's a very difficult moment for various reasons. Of course, one of these are the wars. But I think it can have an influence on values, and it certainly has an influence in shaping the rules of the international business environment. For the fact that, as I mentioned before, it is an organization which produces a lot of rules. It's a regulating entity. It has the will, the capacity, because to regulate you have to be to have a technical expertise, and of course the the fact that you are a very important market, you have an effect on the rules outside your borders. And a certain autonomy from member states as well, although it is an entity created by member states, it has a certain level of autonomy vis-a-vis its member states. So I would say yes, it's a word actor. The second question is, if it's a word actor, what kind of human rights are we talking about when we ask ourselves whether the European Union can have an impact on human rights outside its borders? I'm sure you already examined, discussed Article 2 of the Treaty on European Union on the values of the European Union. I won't repeat it. I will spend a few minutes, even less, on Article 3.5 of the Treaty on European Union. I'm sure you have already seen the article, this provision. I underline here a few words in its relation with the wider world. The Union shall uphold both its values and interests. So, of course, we are not naive to say that the European Union external relations or tools are as an objective to promote the rights, to promote its values. Of course not, it promotes its interests. So we have to be very well aware of the fact that often values and interests clashes, they clash very strongly. Can we take some? Can you give me some example? Can you think about something about this tension, yes, between the values and promoted values, affirmed values, and real interests? Yeah. Women.
Well, for example, some kind of agreements about trade and human rights, like working environment, maybe between USA and third countries most of the time. I know it's not an EU example, but fine.
Yes, of course, the problem of labor is a very crucial one because in many countries we know that there are very poor labor conditions. Workers are paid really low salaries, and there is also this plague of child labor. And this is a huge problem, and we will see in a moment how the European Union tries to tackle with this. I was thinking, for instance, someone else is okay. I don't know, it's women before.
I was talking about the migrant deal with Turkey by the EU.
Yeah. Yeah, can you explain to the others maybe?
Yeah, I think it was a deal to let migrants
Give migrants
migrants well outside of the EU instead of where maybe they wouldn't get treated as in the EU.
Yeah, it's a deal as the European Union pays a lot of money to Turkey to keep migrants to avoid to keep them within its borders, and in order that not to arrive to the shores of Greece or Italy. And the problem is also that we don't know, or really yes, we know how the conditions they live in Turkey are. So this is really a clash between professed values and the reality and interest of, I would say, the member states of the Union more than the Union itself. Yeah. Some other examples?
Trade with countries that don't have rule of law and don't respect the fundamental liberty.
Yeah, for instance, I was thinking that one could think of the situation in Tunisia. Here, there, as well for migration control reasons, the European Union paid or said to pay, committed to pay, to give financial aid to a government which is well, whose standards of respect of democracy and the rule of law are very low, to say the least. Another example is always migration, but it's the big issue nowadays. I was thinking also of the fact that Frontex, which is the agency which control outside border of the European Union, has been accused of pushback of migrants who might have the right of international protection because they escaped from war or from the danger of being tortured. So, in fact, we have to be aware of this contrast between the values, past values, and the interests. This was the first observation I wanted to make. The second one, I continue to read Article 3.5. It shall contribute the European Union to peace, security, sustainable development of the earth, solidarity, mutual respect of peoples, free and fair trade, eradication of poverty, and the protection of human rights, in particular rights of the child. So there is no definition of human rights. What human rights? We can distinguish different kinds of human rights: social rights, economic rights, political rights. The reference is in general to human rights. Also because the European Union consider human rights not to be distinguished. So protection of human rights, it doesn't mean that you can protect civil rights but not economic rights. So human rights, according to the European Union, are indivisible and universal. And there is no space to relativism for the European Union. So we will see later on about the content of the human rights laws included in the agreement, and you have to be aware of this approach of the indivisible, universal, and non-relativism of human rights. So the value interest we already discussed. You see, I put the case of not a full more, but we discussed. For labor conditions, was one of you rightly observed the fact that there might be a clash, there is a clash also on the labor condition in some countries, and the fact that these goods enter the European Union market. So it's true. We will see when talking about general system of preferences that conditionality is linked to the conclusion by third states of some international level organization conventions on the protection of labor. But we have to be also aware that there is an interest of the European Union to ensure level playing fields and to fight social dumping. There is an interest, of course, it's a value in itself, that you have a good level condition, a good salary, But on the other hand, there is also an interest on the part of the European Union that the products that enter the market are not too low. They don't. The price is not too low. Otherwise, there is unfair competition with products produced in the market, where in the European Union the wages are higher and the conditions on level are different. And to end this part of our discussion, there is a mandate to promote values in Article 21. I mentioned it before. Is an important article. I guess you you have already discussed this provision, but I want to stress the universality and divisibility of human rights. I mentioned it before. So Article 3.5 make a reference to human rights in general here. As I already said, the treaty make reference to this approach of the European Union to human rights, universality and indivisibility. So to sum up the first part, the question that I ask, in the European Union, a world actor which is capable, which has the tools to affect promotion, protection, human rights, to affect rules in general terms outside its borders. So we agree that the European Union has limits in itself because it's not a state, it's an international organization. It can act only if it has competencies to do that. But at the same time, it has important competencies. Trade is a conferred competence, so it's a competence that the European Union has, and I didn't say it before, but it has an exclusive competence. What does it mean that the common commercial policy is an exclusive European Union competence? Yeah?
Goes directly to the European Union states, because there is the complementary where it's both the states and the union.
Okay, the competence, yeah. Someone else raising something?
The EU has exclusive rights to the state.
Yeah, in common commercial policy, member states can do it only if they are allowed by the European Union, and if they execute rules that are enacted by the European Union. So it is a very important tool. Also because the notion of trade has been interpreted in a wide sense by the European Court of Justice. So it has a limited competence, but it has an important competence of regulating trade and this is excludes member states' competence. So it has a crucial competence and has a power to affect the international trade rules and also mainly human rights. So the main tools, what are the tools? The question was what are the main tools? Of course, international agreements, but also unilateral measure can have an impact. Human rights, where do we put them in the context of European Union values, as we saw in Article 3.5, Article 21. So this the other part of the second part of this lecture is the human rights as limits to action. I remind you the question was, when concluding international agreements, what limits, if any, do human rights obligations impose on European Union? So this is the question. Why is important? Because, as I said, the European Union, as an obligation, the European Union institutions are obliged when they act, and they act through production of legal rules. They have to respect human rights. Human rights as listed in the Charter, the European Union Charter of Fundamental Rights. So human rights are also a limit for the European Union when it adopts legal acts, when it concludes European Union agreements. So if we focus on international agreements concluded by the European Union within the limits of its competence, the issue is that the European Union shall avoid violating human rights when concluding agreements. Now the question is, how can one violate human rights when it concludes an agreement? Not easy to see the connection, and the connection is not a cause-effect relationship. It depends the fact that the European Union agreement can have an impact, a negative impact on human rights of course, the partner, the third country, depends on different situations, depends on the country, depends on various elements. So there is not, I repeat, a cause-effect relationship. But let's make some example on how a European or an international agreement, no, European one, we are talking about European Union, but also a state agreement with another state can affect human rights. For instance, this was already mentioned, export of labor-intensive goods. They might encourage child labor or labor by women in certain countries which are paid with very low wages, or the application of low labor standards. So this is, of course, as I have said, not a very clear cause-effect relationship, but there might be connection between an agreement which gives the third country very good tariff reduction, very good preferences for the products of the third country to enter into the European Union market, but this could encourage some violation in the labor standards. Or the export of certain agricultural goods could have an impact on communities that are vulnerable to food security. Or could the agreements and increase of export of water for land-intensive industries can have an impact on the access to water of the population of the exporting country. Or this is quite a very clear example, regulation of patents of traditional knowledge or drugs, medicines can have an impact on the price of medicines in countries, or an impact on traditional knowledge of indigenous peoples. Another example one can make is the fact that these trade agreements are no more reciprocal. In the 80s and the 90s, the trade agreements concluded by the European Union with some countries, for instance, in Africa, under the Lomé Conventions, were preferential agreements. That is, the European Union partners in Africa, Caribbean, Pacific states were allowed to keep their tariff protected. They were allowed to keep high tariff duties to protect their markets. So the item X produced by the European Union imported into Gambia had to pay custom duties of 20%. Whereas the products produced in Gambia entering the market of the European Union, where this item did not pay custom duties. So there was a preferential trade agreement. Nowadays, the agreements are no more preferential. Both sides have to review, both partners, European Union, member states, and third country have to reduce their tariff, the custom duties. And so for many countries of what we call now the global south, duties are very important because our tax revenues, they are used to finance health services, schools, and so on and so forth. So this is these agreements, since they are not more preferential, they have a strong impact on poor countries' finances. So these are examples of how an agreement, trade agreement, can have an impact on human rights on the partner of the European Union. So, what can the European Union, or what it has to do, or what it can do to avoid or to try to avoid this impact, this negative effect? Of course, the position of the European Union is to try to avoid as far as possible this effect. How? One of the instruments is impact assessment. Since there is not a clear relationship between the conclusion of the agreement and the negative impact, the European Union has to consider all the possible impact that the agreement that is being negotiated can have on its partner economy, a situation in level standard, and so on. So an impact assessment is an identification of problems and the objectives of the agreement intends to attain. It has to develop different policy options, and then to choose which is the best one. And it requires stakeholders consultation and strong data collection, just to have the pictures, all pictures as as clear as possible. What if the European Union does not make an impact assessment? The European Union institution took the obligation to have an impact assessment whenever they enact legal regulation against in general legal acts. They should do that also when they conclude, when they negotiate and then conclude agreements with them. And we have a very interesting case regarding Vietnam Free Trade Agreement, European Union Vietnam Free Trade Agreement. And there is the ombudsman, European Union ombudsman, that considered that the fact that the Commission did not have an impact assessment before concluding, before negotiating the European Union and the Vietnam Trade Agreement was a case of bad administration. And what did the ombudsman say? It's true that the ombudsman said that because it's true that there is no obligation in the treaty or in a legal act to carry out a human rights impact assessment concerning relevant free trade agreement. But the ombudsman, she took the view that it would be in conformity with the spirit of the legal provisions mentioned above, that is Article 21 of the Treaty of the European Union, to carry out a human rights impact assessment. It's true that the Commission said, well, we had an impact assessment when we were negotiating a treaty with the Southeast Asian nations, but back in 2009, but the ombudsman said it covers only certain aspects of the impact on social rights. It's not a proper substitute for a human rights impact assessment. So what the European Commission has to do is to consider all possible effects that a trade agreement may have as far as human rights are concerned in the partner country. Now let's go to the last part, part 3. So the part 2 was the question was human rights are the limits for European Union when it negotiates and concludes trade agreements. And now we can ask ourselves what are the tools, what are the mechanisms that the European Union can use to protect human rights in third countries through European trade agreements. Which is the mechanism? Which is the mechanism? How can it affect human rights abroad? Through conditionality mechanism. To have conditionality, you have a donor, a recipient, a certain behavior required, and an advantage or disadvantage. So the element of conditionality, external conditionality, because there is also internal conditionality, but we are talking about the relationship of the European Union with the third countries. So the European Union can grant an advantage, benefit to a third country, so it's positive conditionality, or it can withdraw a benefit, an advantage. And in this case, we have negative conditionality. This advantage which is granted, or case of negative conditionality, the benefit which is withdrawn, are dependent on a certain behavior of the recipient country, the third country in this case. A behavior which is decided in the agreement, in principle, by the partners, by the European Union negotiating with a third country, South Korea, Canada, Singapore, okay. But it must be very plain that is the European Union which decides, which imposes the inclusion of human rights clauses. And this creates problem with the European Union partners. For instance, Canada did not want to have this clause, refused, but then it accepted a certain formulation. Some countries prefer not to conclude the agreement with the European Union because it contained a human rights clause. So it's a problem of for the European Union to insist in certain cases on the inclusion of the clause. So the behavior required can be positive. For instance, the third country is required to sign, conclude, to ratify a number of conventions on protecting human rights or protecting labor conditions or protecting the environment. Or negative, they have to abstain from a certain behavior, not to violate human rights, not to violate those conventions, for instance. I make some example in a moment. What is the rationale of conditionality? I think it's quite clear. It's a leverage mechanism. I reward you if you behave well. I punish you if you don't behave well. So it's a way of conditioning the partner behavior. Of course, we are talking about human rights, environmental protections, level standards, in this case of the human rights clause. So, for instance, if you take the GSP, General System of Preferences, I told you that the European Union can affect the situation in third country also through unilateral measure. The GSP is decided by the European Union by regulation, so it's a unilateral act of the European Union. And what is the General System of Preferences? Is a scheme, is a system whereby the products, the goods produced in certain countries, poor countries, can access the European Union market without paying or with a reduction of custom duties. So it's an advantage for cotton products made in Pakistan to enter the European market with a reduction from 20% tariff custom duties to 5%. So the general system of preferences is a tariff preferential access to the European market. But there are further tariff reductions if the beneficiary countries satisfies a number of conditions. So if, let's say, Pakistan can, under the general system, export its cotton garments to the European Union, paying 5% custom duties. If it ratifies some a number of International Labour Organization Convention on labor standard, it has a further advantage of not paying at all custom duty. So it enters its cotton garment are imported into the European Union market without paying any custom duty. This is a very basic example of conditionality established unilaterally by the European Union. But human rights clauses are something different. These are conditionality tools, but they work a little bit different. First of all, they are included, as I said, in agreements, in international, in agreement concluded by the European Union, usually it's member states on the one side and another country on the other side. The human rights clause, in fact, is made of two provisions. One is the essential element clause. I read a couple of clauses to give you an example. So you find in the first provisions of the agreement, Article 1 or 2, general principles, you find the clause, and the clause in fact said what? That respect for human rights and other values are an essential element of the agreement. This is the first part of the clause. Then you have in the final provisions of the agreement a non-execution clause, which says when the parties of the agreement, so even the European Union, because it works both ways, even if it's clear that it works especially in one way, that is when the European Union partners violates the essential element clause, the other party, in this case European Union, can adopt some measures. In fact, it can suspend the agreement. So I repeat, the human rights clause is made of two provisions. One is the essential element clause, and the other, which is clearly connected, is the non-execution clause. Why this structure of the clause? Because the origin dates back to the 80s, when in Uganda there was a very bad dictatorship, and the European Union gave Uganda a lot of money through financial aid, through one of these agreement concluded by the European Union with by the European Community at the time with some African countries. So there was a reaction also in the public opinion, the European Union, that we, the community, finance a dictatorship like the one that. So the European Union did not know how to suspend the financial aid, because this financial aid were provided for in the agreement. So the European Union was obliged under international law to pay this money to Uganda. So the community decided to include in the future agreements this human rights clause, which allow the European Union to suspend the agreement in case of a serious violation of an essential element of the agreement. And this is provided for under customary international law. One contracting party can suspend or even terminate an agreement if the other party violates, commits a serious violation of an essential part of the agreement. So this is a mechanism reproduced in every European Union agreement, which allows the European Union, but also the other party, to suspend the agreement in case of a serious violation of the values inscribed in the first part of the provision, the essential element clause. Is it clear? I read one or two of these clauses. This is the old Cotonou agreement with Africa, Caribbean, Pacific countries. Respect for human rights, democratic principles, and the rule of law. So not only human rights, but also democratic principles, rule of law, which underpin the ACP-EU partnership. It means that the respect of these values are at the basis of our relationship. Shall underpin domestic and international policies of the parties and constitute the essential elements of the agreement. So the essential elements of the agreement is respect of certain values. They are not defined which human rights. They are not defined. Human rights, democracy. What is democracy? Is not defined. But this is also very important provision because it's a basis for dialogue between the parties. So it's connected, this provision, this first part of the provision, the essential element clause, is connected, as I tried to explain, with a non-execution clause, but it is also a positive clause because it's the basis of a dialogue between the parties. Because the non-execution of the agreement is the last resort, is a measure of last resort. And the European Union never suspended the trade part of the agreement when it applied the clause, and it applied the clause, I think, no more than 25 times. So it's not using the clause very much, but it wants to include the clause in all the agreements that it concludes with African countries, with Eastern Asia states, with Canada, with Australia, with Japan. It's a practice of external policy. Another example, essential element clause in South with the framework agreement concluded with Korea, South Korea, of course. The parties confirm their attachment to democratic principles, human rights, fundamental freedoms, the rule of law. Respect for democratic principles, human rights, and fundamental freedom as laid down in the Universal Declaration of Human Rights. Here we have the reference to an instrument, which is, by the way, not a binding one, because the Universal Declaration of Human Rights is a recommendation of the United Nations Assembly. It's not a binding agreement, but of course is a reference for human rights. And other relevant international human rights instruments. So this is a expression very general. It's I think that the objective of saying other relevant international human rights instruments, of course, instruments which binds the partners, bind the member states, binds the Korea, South Korea, but also those instruments that might bind the Korea, bind South Korea in the future. But they are not defined, they are not listed. In the general system of references, the conventions that the beneficiary country has to conclude to benefit from these extra tariff preferences are listed in an access of the regulation. So it underpins the international policies of good parties and constitutes an essential element of the agreement. This clause is contained in the framework agreement concluded by the European Union and South Korea. Then we have a trade agreement which does not contain a human rights clause, but there is a linkage clause which connects the trade agreement between the European Union and South Korea to the framework agreement. The trade agreement shall be an integral part of the framework agreement. The trade agreement constitutes a specific agreement giving effect to the trade provisions within the meaning of the framework agreement. This is not very clear if you don't know what the aim of this provision is. That is connecting the framework agreement with a more specific agreement, trade agreement concluded by the European Union, which has exclusive competence to do that. And it's connected to the framework agreement. Therefore, this means that if there is a serious violation of human rights or democracy in South Korea, the European Union can trigger the clause, the non-execution clause, because the trade agreement is connected with a framework agreement which contains the clause. Is clear. Another example, which is very interesting, is the agreement with Georgia.
There is a excuse me, there is a.
I'm sorry, I see your hands.
No, it's not a question. As just to know that she's from Georgia.
Oh, okay.
I just realized.
Respect for democratic. No, don't worry. Respect for democratic principles, human rights, and fundamental freedoms, as proclaimed in the United Nations Universal Declaration on Human Rights of 1948, and as defined in the European Convention for the Protection of Human Rights and Fundamental Freedoms of 1950, the Helsinki Final Act of 1975, and the Conference on Security and Cooperation in Europe, the Charter of Paris for a New Europe of 1990, form the basis of domestic and external policy party and constitutes an essential element of this agreement. Why this? There is this difference. Of course, because Georgia is in Europe, and so the mention is to the European Convention for Protection of Human Rights, the 1950 Convention of the Council of Europe. And is also it's also clear why the Helsinki Final Act and the Charter of Paris reference, because these are the documents which were adopted a century, but were the basis of the new relationship between the Eastern and Western and Eastern Europe. So they are recalled in the Georgia human rights clause. In Ukraine, there is an addition. The clause is the same as in the one we saw for Georgia association agreement. In the Ukraine association agreement, there is an addition, proportion of respect for the principles of sovereignty and territorial integrity, inviolability of borders and independence, as well as countering the proliferation of weapons of mass destruction. It's very interesting. We have a reference to the principle of territorial integrity and inviolability of borders. But why to have this clause in the Ukraine association agreements? In fact, it's not Ukraine which was a danger for unavailability of borders of other states, it's the other way around. So why to have this reference? It's not Ukraine that's violating borders.
It's Russia in.
When Russia invaded Ukraine, the European Union adopted serious sanctions under the foreign policy of the European Union. It's not Ukraine that was going to be sanctioned.
It's like a declaration within all the territory of Ukraine and the occupied the EU law exists, even the occupied region.
Sorry, I couldn't hear you very well. The last part of your sentence.
Even in the regions that are occupied or will be possibly occupied even after the annexation, so that the EU law can also have claim in these regions. So the territory is inviolable anyway.
Yeah, I don't. I mean, I asked you the question, but I don't know the answer. I think that maybe it's because the European Union is very, it was very aware of the problem, of course, between Russia and Ukraine. So it's included this in the Ukraine Association Agreement because it could not include it in a Russian agreement, in an agreement with Russia. So just to sort of warning of an expression of the position of the European Union towards integrity is very important. Is a basis of international relation that states, sovereign state cannot be invaded or occupied by other states. I don't know. It's a question that I asked, but I don't really have the answer. But it's very interesting that the essential element clause contain this reference. So I think we can skip this and go to. So I already explained the non-execution clause, and in some agreements, before triggering the non-execution clause, before the adoption of appropriate measures, there must be a period of consultation with between the contracting parties, or even an arbitration procedures in some cases. So what are, I'm going toward the end of this discussion, the limits of human rights clauses. The limit is that, first of all, the European Union has been accused of triggering the clause only in relation to agreements and to violation of human rights in some countries in Africa. So the European Union has been accused of not being I missed the word. Not to treat all in the same way, to make different treatment according to different states. Then the clauses, the trigger of the clause depends on discretionary power of the European Union institution. There is also a case before the European Court of Justice, and the Court of Justice recognized that in fact the triggering of the clause depends on a political decision of the European Union institutions. And you need a consent of the partners to include the clauses. I mentioned before, some countries refused to conclude agreements because of the human rights clauses. They were totally in disagreement with the European Union. They didn't want this provision in the agreement, so they prefer not to have an agreement at all. And there is also a changing environment, I would say, in nowadays, because the European Union is aware that other states do not make conditionality, they don't include conditionality mechanism in their agreements. They do business with some countries without bothering about the human rights protection. So to say it in a more elegant way, there is less emphasis by some countries like China on human rights than in comparison with the European Union approach. It's clear that the human rights is a conditionality mechanism, because if you don't accept the clause, you don't have an agreement with the European Union. If you don't behave well, if you commit serious violation of human rights, of democracy, of the rule of law, you might have as a result that the agreement can be suspended or even terminated. But what the European Union makes clear is that it prefers dialogue, and it's using the clause, the first part of the clause, the essential element clause, as a basis for dialogue with the third countries. And the institutions are very clear on that, at least the Commission. The European Parliament has a different position, because the European Parliament is much more hard on including human rights clauses and in triggering human rights clauses than the European Commission. But the European Commission prefers dialogue, prefers to have positive incentives instead of measures that can be resented by the third countries as sanctions. I think we stop here. I had some other things to say, but I think we'll have another lecture, so I promise you to finish before past 4:30, but I'm sorry. I'm late.